So for those of you who don't already know me or don't know Digiphile, my name is Phil Lee. I am a zettabyte lawyer here at Digiphile, which is the very grand title I give myself for being the managing director. Digiphile is a newly launched UK law firm. We just started trading in January this year. We are a challenger law firm, and we specialize in data privacy, cyber, and AI work. Now, what a great topic we have to talk to you about today. We are going to be discussing the EU-US data privacy framework. Been getting a lot of attention recently. And what we hope to do today is to take you through a number of different things. So this is our agenda just coming up. We are going to look at how did we get here? How did we arrive at the data privacy framework? We will look at why was the previous framework, the Privacy Shield, struck down? And has anything really changed with the new data privacy framework? We will look at practical steps to certify. If you were thinking of going through the data privacy framework, then we have some good news for you. You are in the right place today. And we will also look at, if you've not yet reached that decision, is the data privacy framework something that is right for you? Now, we are hosting this session on a platform called Session. And one of the things that it actually enables you to do is to submit little reactions to slides as I'm going along. So if there's anything you particularly like or something you want to react to, you can click the buttons below and do a little thumbs up or a smiley or whatever you want to do. Or you can just sit there and listen. The choice is entirely yours. We also have a Q&A panel, which you hopefully can see in your screen. A few thumbs coming up now. Love it. This is brilliant. Makes presenting that much more fun. There's a Q&A panel. If anything occurs to you, questions that you have as we're going through, please feel free to submit them. I will do my best either to answer them as I go along or to do a sweep up at the end and answer those that we have time for. So let's begin. Now, to take you through the history of this, back in 2000, the European Commission and the US Department of Commerce adopted what was then known as the US-EU Safe Harbor Framework. This was an initial framework agreed between the US and the European Union to enable transfers of data from the EU to organizations that had certified under the Safe Harbor framework in the US. And this was made under the previous data protection law, the old Data Protection Directive. And I particularly want you to just note, when you look at this slide, it was called the US-EU Safe Harbor Framework. I will come back to that point in a moment. So for a period of time, the US-EU Safe Harbor Framework chugged along quite nicely. About 3,000 organizations had certified under it and were receiving data lawfully from the EU. But then in 2015, a privacy campaigner I'm sure you have all heard of, called Max Schrems, challenged the validity of Safe Harbor. He did so before the Irish Data Protection Commission, and that case went all of the way up to the European Court of Justice. And what happened? Well, this happened. The Court of Justice struck down Safe Harbor over concerns around disclosure of data to law enforcement and intelligence agencies and the fact they weren't properly covered by Safe Harbor, and the whole house of cards fell down. So, undeterred, the European Commission and the US Department of Commerce went back to the drawing board. And in 2016, just a year later, they announced the new EU-US Privacy Shield framework. Now, you remember right at the very beginning, I said, just notice in that first one, it was the US-EU Safe Harbor. This time around, it was the EU-US Privacy Shield, the EU coming first. And I always think when it comes to politics, it's quite telling where the balance of power lies in terms of who gets cited first in the title. So this time round, you can see the EU was perhaps in the driving seat when it came to these discussions. Now, once again, Max Schrems raised concerns about the Privacy Shield. He actually described it as, if I remember rightly, putting lipstick on a pig. He saw it as basically taking the same problems that existed with Safe Harbor, dressing them up a bit more, and then just reusing them. So in 2020, he challenged it again. The case went up to the Court of Justice of the EU, and this happened. Once again, the Court of Justice struck down the Privacy Shield framework. So, undeterred, the European Commission and the US Department of Commerce adopted yet another framework. This time we're calling it the EU-US Data Privacy Framework. That is the framework that has just recently been the subject of an adequacy decision in the EU, and is, of course, what we are here to discuss today. But already there have been concerns raised. Earlier this month, French MEP Philippe Latombe announced a challenge to the DPF, seeking to get it annulled. And inevitably, Max Schrems has also announced his intention to challenge the DPF. So it looks very much like we are headed for further cases before the European Court. From what I was reading earlier today, the money is on Max announcing his challenge to the DPF around October the 10th. So that will be a date to watch out for, and I will come back to why it will be that date a little bit later on. So the question on everybody's mind is, will this happen again? Well, the short answer is we don't know. There have certainly been some steps taken with the data privacy framework to try to address some of the concerns that had existed before. So before we get to those, let's just step back a moment and actually ask ourselves the question, why was the Privacy Shield framework shot down? Well, fundamentally, the concerns that were raised at the time and that the European Court of Justice weighed on quite heavily were concerns to do with US surveillance. And these were the revelations that had arisen out of the Edward Snowden disclosures that pursuant to a law called FISA 702, Section 702 of FISA, and an Executive Order 12333, the US was engaging in surveillance activities, particularly bulk surveillance activities that enabled the collection of data over the internet backbone in a program called Upstream, or that compelled large technology companies to disclose data about individuals under a program called PRISM. And Executive Order 12333 enabled sort of even more covert surveillance activities to go on. And when these issues were raised before the Court of Justice, the European Court had to look at how these issues related to sort of European principles of necessity and proportionality. Basically, under European law, we have this thing, the Charter of Fundamental Rights. It sets out, it's kind of like a Bill of Rights, if you're a US attendee to the audience. So it's like the European Bill of Rights, and it enshrines a right to privacy, it enshrines a right to data protection in addition. And it basically says that those rights can't be interfered with except in sort of very limited circumstances, which can include legal scenarios, but that any interference with them has to be limited by principles of necessity and proportionality. And what the court said was that these kind of bulk data collection regimes that were going on in the US were not limited by these principles of necessity and proportionality. It was a massive hoovering up of data, and that was incompatible as it related to EU data being transferred to the US. It was incompatible with those EU principles. And if you think that the purpose of the Privacy Shield framework, or indeed any adequacy decision, is to ensure that sort of European data, when it moves overseas, is being protected to a standard that is adequate or essentially equivalent to European data protection law, the court was saying that because of this lack of necessity and because of this lack of proportionality, that data standard wasn't being met. And so that was the first concern. The second key concern was that the court said there was a lack of effective and enforceable rights for data subjects. So under the previous Privacy Shield, there was a Privacy Shield ombudsperson who was there to kind of oversee privacy concerns around some of the surveillance activities that were going on. But the ombudsperson was appointed by the Secretary of State. They were supervised by the Secretary of State, and so the court held, well, they weren't sufficiently independent. And another concern they had was that the ombudsperson, if they did investigate any surveillance-related issues, they didn't have the power to make any binding decisions. And further, there was no general standing for European citizens to challenge any surveillance activities before US courts. And so because of all of these issues combined, there was no effective and enforceable rights for EU data subjects. So lack of necessity, lack of proportionality, no effective and enforceable rights, and the Privacy Shield was shot down. So what has happened since then? Well, the first step along the path to getting the data privacy framework adopted was that the Biden presidency adopted another executive order, this time called Executive Order 14086. And that did three key things. The first was that it established that what we call signals intelligence activities, that's these kind of surveillance activities for intelligence purposes, could only be conducted for validated intelligence priorities. And within Executive Order 14086, it sets out certain activities that are considered legitimate to do signals intelligence and certain activities that are considered illegitimate to do signals intelligence. So there was a kind of scoping of the intelligence activities that were permitted. And Executive Order 14086 expressly says that not only do they have to be conducted for validated intelligence priorities, but the activities undertaken have to be necessary and they have to be proportionate. And that targeted surveillance is to be prioritized over any form of bulk collection. So immediately you can see that the executive order is kind of getting to the heart of what was the CJEU's concerns by introducing these principles of necessity and proportionality. Whether they do that effectively enough is a matter for debate, but that was the aim. The next thing they did was to replace the role of the privacy ombudsperson with a new civil liberties protection officer, who is an officer of the Director of National Intelligence, and the post is currently held by Rebecca Richards, whose image you can see here. And the CLPO has the responsibility for validating intelligence activities and that they are kind of complying with the requirements of the executive order. And they also investigate complaints that surveillance activities are infringing on privacy and civil liberties. And the CLPO has the ability to make binding decisions. So again, addressing part of the concerns around the previous court ruling that there was no power to make binding decisions. In and of itself, the CLPO is probably not sufficiently independent, given that they have that kind of role within the Office of National Intelligence. But the executive order went one step further, and they established a data protection review court. And this is essentially kind of like an appeals process under the executive order, whereby individuals who are unhappy with a finding from the CLPO can appeal up to the Data Protection Review Court, who will then investigate it and again can make binding decisions. Now, importantly, the court, and I've used court in inverted commas because it's not a court in the sense of a traditional US court, but the court is made up of experienced practitioners, data protection practitioners, who are not current US government employees. So again, trying to establish that independence that was lacking under the previous Privacy Shield regime. So that's the good news. The executive order has taken a number of steps to try and address the previous concerns of the court. And that executive order then led to the European Commission making a finding of adequacy for the data privacy framework. Now, just one kind of small pro tip here for any of you. You will often hear people talking about Privacy Shield sort of in the same breath as standard contractual clauses. It's a very technical point, this, but not Privacy Shield, data privacy framework. The data privacy framework is an adequacy decision. So in the same way that there are certain countries that are deemed adequate, that are deemed safe to receive EU data, that's the same thing that as the data privacy framework. If you are an organization that is certified under the framework, you are deemed safe to receive data. Now, the reason that distinction matters is that when you transfer data under an adequacy decision, there is no need to conduct a transfer impact assessment. Whereas when you use a different mechanism, appropriate safeguards, which is what standard contractual clauses are, transfer impact assessments are still necessary. So just a small thing to keep in mind there. So we had this adequacy decision for the data privacy framework, and that happened in July. And just a week later, the Department of Commerce then launched the new data privacy framework website, where you can go and self-certify, see the text of the framework, see who's currently certified under the framework. And I tend to liken the way that the DOC launched this as being a bit like Meta's launch of Threads. So you probably may have heard of Threads, the kind of the messaging app, the sort of social media kind of competitor to Twitter, and it had a very successful takeoff, in part because everybody who was an existing Instagram user was automatically kind of ported onto Threads. It's a similar thing with the data privacy framework, in that everybody who is an existing Privacy Shield holder kind of automatically, for a period of time, is kind of ported into the data privacy framework and is deemed adequate. And again, I will return to that. But of course, not everybody is happy. We already know that Philippe Latombe and Max Schrems are not happy. But even before that, the European Data Protection Board and the EU Parliament were raising concerns. So in February of this year, before the adequacy decision was announced, the EDPB released its opinion on the data privacy framework, and a few months later, the European Parliament issued a resolution basically calling upon the European Commission to go back and renegotiate better protections for European citizens. And there were a number of concerns that have been sort of cited here. The first is to do with the relative complexity of the data privacy framework. I will say, as a data protection practitioner, I have to go away and I have to read Executive Order 14086, which, frankly, is pretty dense to try and get through. You also have to go and look at the data privacy framework itself, which is divided into a bunch of principles and then into a bunch of supplemental principles, and it is quite difficult to stitch the whole thing together. So one of the concerns there is around the complexity and the fact that that complexity leads to a lack of transparency to data subjects. So the concern number one. The second concern with the data privacy framework that the EDPB and the Parliament raised were that it was kind of perpetuating some of the problems that existed with the Privacy Shield. What do we mean by that? Well, under the previous Privacy Shield, a number of folks, and not least the EDPB and Parliament, had raised concerns that there were aspects of the Privacy Shield that didn't match up very well with European Union law. So, for example, when you look at the rights to access and the exemptions from it, they're slightly different to how they work under the GDPR. Similar, but not the same. Similarly, the Privacy Shield principles don't deal very well with the whole concept of data processors. It's very much a text that's really geared towards being a data controller. And when the data privacy framework was adopted, it basically adopted the Privacy Shield principles wholesale and sort of, kind of like a bit of a global find and replace the words Privacy Shield with data privacy framework, but otherwise made very few changes to them. So some of those issues that existed before continue to exist under the data privacy framework. The EDPB also had concerns about onward transfers. So there are controls under the data privacy framework if as a DPF certified organization, you transfer data to another processor or another controller, but they don't really explicitly very clearly deal with what happens if you're transferring data onward to a third country. So, for example, you might be an EU organization transferring data to a DPF certified organization in the US, but what happens if it then transfers data to another organization outside of the US? There's a bit of uncertainty around some of that. And then the big concerns were that the bulk collection is still permitted. The FISA Section 702 still exists. The Executive Order 14086 still allows for bulk collection. It prioritizes targeted collection over bulk collection, but does acknowledge that in certain cases, bulk collection should still be permitted. And any form of bulk collection is just a big concern for European regulators and and European courts. And then we've talked about the the investigations process where the Civil Liberties Protection Officer can investigate complaints of unlawful surveillance, and that can be reported up to the Data Protection Review Court. But what happens? What happens if the, what does the CLPO, what does the Data Protection Review Court tell a data subject about their investigation? Well, the answer is this. Once they've conducted the investigation, they will write back to the data subject and they will say, the review either did not identify any covered violations, or the Civil Liberties Protection Officer or the Office of Director of National Intelligence issued a determination requiring appropriate remediation. Full stop. But if you make a complaint, you will be told either there was nothing to see, or there might have been and we fixed it, so don't worry. But you don't find out any further information about the nature of the investigation, the nature of the violation, any of those kinds of things. Now, just in fairness and for completeness, there is a process within the executive order that says that, these kind of complaint investigations have to be reviewed every 5 years. If the complaint can be declassified, then further information can be released. But at the initial time of complaint, you don't get told a lot about the validity of your complaint. And for those of you who are familiar with the previous Privacy Shield, you will see here that all of the principles I'm listing here under the Data Privacy Framework are essentially the same as existed under the prior Privacy Shield. So for those of you who are a bit less familiar with it, what you have on the left-hand side is a column for principles. These are the main principles of the Data Privacy Framework. Similar in a lot of ways to GDPR principles. You've got notice or transparency, choice or lawfulness, accountability for onward transfer, limited controls around transferring to other controllers or processors, requirements for security, data integrity and purpose limitation, that a principle around access, which actually isn't just access, it's also, objection and correction, so on. And then a principle around recourse, enforcement and liability. And then those principles are further interpreted and scoped by these supplemental principles, of which there is a further 16 of them, which again goes a little bit to what I was discussing about some of the complexity of understanding this. You can't just go to one principle and understand it. You then have to see whether there are other supplemental principles that further interpret it. So, will it survive? The short answer, I don't know. You can certainly see that there have been a lot of steps taken to try and address the concerns of the court. You can also see that there are some valid concerns that remain about the data privacy framework. The key concerns around necessity and proportionality and around independence seem to have been addressed. But there are, the bulk collection, which was the driver for previous regimes being shot down, is still a possibility, albeit that it has been sort of more narrowly scoped. Now, nevertheless, what we are seeing with a lot of organizations is that a number of them previously had Privacy Shield certifications that they maintained and they want to continue under the DPF. And frankly, commercially, there's a lot of pressure for a lot of vendor organizations to do the DPF anyway. So if you are thinking about certifying, what are the things that you need to do? Well, first off, the first thing you need to do is to decide the scope of your certification. When you certify under the DPF, you can certify for EU, UK, and/or Swiss data transfers. So in other words, you can use it as a mechanism for safely receiving data from the EU, the UK, and/or Switzerland. Now, slightly confusingly, while you can certify for data transfers from each of these regions, at the moment, the UK and Switzerland have not yet declared the data privacy framework to be adequate in the way that the EU has. So you can certify under them, you just can't rely on it yet for the UK and Switzerland. You can from the EU. The UK certification does appear to be imminent. One of the key steps for the UK being able to issue adequacy regulations for the data privacy framework is that it has to be designated a qualifying state by the US, which has just happened just the other day. So it looks like the UK the UK regulations will be imminent, but they're not quite in place yet. So first off, consider the scope in terms of geography. Which regions are you going to certify to receive data from? Secondly, consider what type of data you're certifying for. Are you certifying for transfers of HR data only, or are you certifying for transfers of non-HR data, so data about your customers or consumers or vendors, or are you doing both? And this matters because the choice of data that you are certified for will influence your decision around the dispute resolution mechanism you use later on, and I will come back to that. And then finally, decide on the scope of your US group companies that are going to be subject to the data privacy framework. One thing we've seen with a few clients already is that typically they will have a US parent that will be starting to certify, but they will also have other US entities. And one thing we've been having to do is to kind of remind them, well, don't forget, if you want all your US entities to benefit from the data privacy framework, you need to make sure that they all certify, not just the US parent. So again, make sure to do that. Secondly, you have to comply with the notice requirements of the data privacy framework. So this is the notice principle. And you can see it on the right-hand side there. The text is a little bit dense, but it, in large part, requires you to disclose the types of things that you would be required to disclose in a GDPR privacy notice. So things like the types of personal data collected, the purposes for which it's collected, and why it's used, the rights of individuals to access their data. All of those things are things that you would do in a GDPR notice anyway. There are other bits and pieces, though, that are specific to the DPF. So, for example, you have to, include the fact that you are participating in the DPF and provide a link to the data privacy framework list. You have to give information about your dispute resolution mechanism and the right for individuals to seek arbitration. So, there's various bits and pieces that are specific to the DPF that won't be in a GDPR notice. So you need to make sure that you do that. And one of the early decisions we've seen people making when they are updating their notices for the data privacy framework is a choice around whether they take their privacy policy as a whole and just edit it to include the data privacy framework disclosures, or whether they have a standalone data privacy framework notice. Now, personally, I prefer the standalone notice approach. And the reason for that is just simply that if you are certifying under both HR and non-HR data, then both of those, your HR policy and your non-HR privacy policy, you can then link to the standalone notice rather than you needing to kind of copy the same disclosures into each notice, which runs the risk that they become inconsistent or sort of, out of touch with one another over time. But again, different people take different approaches. Next step, you need to update your contract templates. I mentioned there's a principle around accountability for onward transfers. And what this says is that if you were sharing data with a third party, what they call an agent, which is a third party processor, then there are certain clauses you have to include in your contract with that third party processor. Similarly, if you're sharing data with a third party controller, there are certain clauses you have to include within that contract as well. Relatively simple, doesn't take up more than a sort of a paragraph of the contract. But you do need to include that language. So, and because you will have to certify as you go through the process of applying that you are in compliance, you need to make sure those templates are brought up to date. Next, opt-out requirements. There are, well, opt-out, we should say, there are opt-out and opt-in requirements that exist under the data privacy framework. The opt-out requirements apply for non-sensitive data, and non-sensitive data has a definition under the data privacy framework. It's very similar to the old data protection directive definition of sensitive data, slightly different from the GDPR definition, so just look out for that. But what it says is that if you are disclosing non-sensitive data to a third party, you have to give individuals the ability to opt out of those disclosures. And if you are going to make a material change of use in somebody's data, again, you have to give them the ability to opt out of that change of use. If it's sensitive data, however, you have to seek opt-in for third-party disclosures, and you have to seek opt-in for any change of purpose. Now, when we talk about third-party disclosures here, I assume we're referring to disclosures to third-party controllers, not third-party processors. But again, this is just a point to be aware of. These are choices you need to be able to offer to your data subjects. Now, a really key decision is that you have to appoint an independent dispute resolution provider. So if somebody has a complaint about your handling of their data under the data privacy framework, then they have to be able to take that complaint to an independent dispute resolution provider. And you have a choice here. You can either use the EU data protection authorities as your dispute resolution provider, and if you are transferring HR data, this is what I said, that distinction is important. If it's HR data, then it's mandatory for you to use the data protection authorities as the dispute resolution provider for HR data. If it's non-HR data, though, you can choose, if you want to use a third-party provider, so somebody like the American Arbitration Association, JAMS, TrustDoc, or somebody like that. And I'm just seeing in the comments, actually, somebody is obviously better informed than me. A shout out here that the UK-US data bridge seems to have happened today and will be in effect the 12th of October. So there you go. There is some good breaking news to share. Next up, if you are going through the process of certifying, be aware of the fees that you need to pay. So there are a bunch of them, in fact, ranging from the small to the not so small. First off, if you are using the EU data protection authorities as your dispute resolution provider, either because you're required to, because you're transferring HR data, or simply because you've chosen to, then you have to contribute to what's called the DPA panel fund, which is $50. So not a huge amount. And just from my perspective, again, I'm sure different people have different views on this, but frankly, when you're choosing your independent dispute resolution provider, it's not a bad choice to choose the DPAs. You know, the reality probably is in a lot of cases that if somebody is going to make a complaint under the data privacy framework, odds are they're going to go to their local DPA anyway. So, and regardless of whether they've also gone through a dispute resolution procedure, most DPAs, I think, would feel duty bound to investigate. So in some ways, you're going to be exposed to the DPAs anyway, so it's not a bad thing to centralize and everything under them. But again, that's just one view. Next up, there is this requirement under the data privacy framework that individuals who are not satisfied with the resolution of their complaints, whether that's going to the company first and then going to the independent dispute resolution provider, they can also take the company through arbitration. And so you also have to contribute to an arbitral panel fund, a DPF arbitral panel fund. And the fees for that vary depending on the site or organization, from a small amount of $250 up to a very large amount of $10,000. Although maybe not so much when you actually look at the scale of organization you need to be to pay $10,000. You can see that just on the screen there. So if you have annual revenue of over $5 billion, it's $10,000. And last but not least, there is your application fee for applying for DPF certification to the International Trade Administration with the Department of Commerce. Again, the fees range from $250 to $4,875, depending both on your size and on which frameworks you are certifying under, whether it is just the EU and the UK extension to the EU framework, or whether it is also the Swiss framework. So just make sure you're aware of all those fees and you write the checks in the right places. Next up, you have to implement a verification program. So when you certify, you, of course, have to confirm to the Department of Commerce that you are in compliance with the data privacy framework. And you can choose either to do that through self-assessment, or you can do that through an external assessment, to have a third-party auditor come in and do that. It's your choice. You will have to annually recertify, so you'll need that verification program to sort of reoccur annually. And again, you can decide which approach works best for you. You have to designate a contact point, so somebody that can be reached for complaints, both by individuals and by the Department of Commerce over any concerns about your compliance with the DPF. And finally, you complete and submit your certification, and the link to do so is on the screen just there. So a few key points to note. Eligibility. Remember that the data privacy framework is only available to organizations that fall under the jurisdiction of the Federal Trade Commission or the Department of Transportation. What that means is that if you are, for example, a bank or a telecoms company or a non-profit that does not fall under either of those jurisdictions, you will sadly not be eligible for the data privacy framework, meaning that you will have to instead rely on something like the standard contractual clauses to make your transfers. There is also a grandfathering regime under the data privacy framework, which is that if you were an organization that was Privacy Shield certified and you have maintained your Privacy Shield certification, you automatically benefit from being grandfathered into the data privacy framework regime, provided you update you make the necessary updates to your notices and to your contracts by the 10th of October 2023. Now, if you remember, right at the start of the presentation, I said that the money was on Max Schrems launching his complaint or his challenge to the data privacy framework on or around the 10th of October 2023. I suspect if the reason for picking that date is because that will be the kind of the final deadline for previous Privacy Shield organizations to have done the necessary updates, and it will then be a relatively easy exercise to check which companies are listed and have not done that update and are out of compliance, which will, if they are out of compliance and still listed, will further cast aspersions on the validity of the regime. So, watch the 10th of October. Next up, we've mentioned the UK and Switzerland can certify under the regime for UK and Swiss transfers, but adequacy is still pending in those countries. But thanks to the breaking news we just heard today, it sounds like the UK adequacy will be in effect from the 12th of October. So we are just waiting then on Switzerland to grant adequacy recognition. And in terms of enforcement, quite aside from the fact that European DPAs could investigate under the GDPR, the FTC has the ability to investigate and sanction organizations under their unfair and deceptive practices regimes. If you don't comply with their sanctions, then you can be exposed to penalties of up to $50,000 per day for violations. So not small amounts indeed, and certainly not something to be sneezed at. So take this very seriously. So what are the benefits of the DPF? We've talked a lot about some of the concerns with the regime. We've talked about the fact that a lot of companies are going to do it anyway. So, why? What are the benefits? Well, the first is, as I mentioned earlier, the data privacy framework is an adequacy decision, meaning that if you were certified under it, you were considered safe to receive data from the EU. There's no requirement when you're transferring data under adequacy to have to conduct a transfer impact assessment or to have to implement supplementary measures. Those things a lot of organizations are finding very difficult when it comes to using standard contractual clauses. In fact, though, there's even more good news than that, which is that Executive Order 14086, which introduced this whole concept of necessity and proportionality and this CLPO and the Data Protection Review Court, actually that applies even to transfers that are made under standard contractual clauses. And I can see some people asking questions about BCRs as well. Yes, it also applies to transfers that are made under BCRs. So the good news is that if you are if you're using standard contractual clauses or you're using BCRs, those are solutions that are considered appropriate safeguards. They still require transfer impact assessment. They still require supplementary measures, but the executive order really helps out there, because you will now be able to say, as part of your TIA, transfers we make under these SCCs to the US benefit from the executive order. It has these principles of necessity and proportionality. There's this whole, CLPO, Data Protection Review Court. So it maybe makes the case for your TIA in and of itself. Certainly, if it's good enough to get the data privacy framework adopted as an adequacy decision, it's hard to see why it wouldn't also be sufficient to make transfers under the standard contractual clauses or the BCRs. Other benefits of the DPF, it's a one-time solution. Once you've got it in place, you can transfer data, back and forth to the US. There's not a need for you to have case-by-case standard contractual clauses every time you bring a new data stream on that wasn't covered by your previous standard contractual clauses. So that makes that nice and simple. You don't start drowning in a sea of contracts. A key thing we've seen with a lot of clients is that it is a customer expectation. And we saw this with the Privacy Shield as well, actually, when that was adopted. And there were similar concerns at the time the Privacy Shield was adopted that it would be shot down, which eventually turned out to be true. But nonetheless, what we found was that a lot of vendor organizations, their customers were coming to them, and either they felt that the Privacy Shield and now the DPF is a better solution because it is an adequacy solution, and so they wanted their vendors to have it, or frankly, they just seen the press releases and thought of it, as something that they needed to have to transfer data to the US. We've seen a lot of pressure on vendors to implement the DPF anyway. So a lot of them are doing it regardless of any kind of personal views about the DPF. They're doing it because the customer pressure is there. And then another key point related to that is what I would call data transfer redundancy. We are living in a world where data transfers have become increasingly more complex, and we are seeing organizations that are worrying about the longevity of the DPF. They're worrying about, in some cases, even the longevity of the standard contractual clauses, or that standard contractual clauses may not cover all of the transfers that they want to do, or that, about the longevity of things like BCRs. So what we have seen with some clients is that they do multiple solutions. They will implement DPF, they'll implement standard contractual clauses, and in some cases even implement BCRs on top of all that. The idea being that if one collapses, they can still try and rely on the others. Just be aware, though, that if you do go through the DPF, there are many, many, many ways for people to complain. So the starting point and the way it should work is that they come to you, first of all, they complain to the DPF certified company. But if they're not unhappy with the resolution they've got there, they can then escalate to the independent dispute resolution provider. If they are not happy with that, they can seek to invoke arbitration, or at any time they could go to their local data protection authorities and raise a complaint, or potentially even complain directly to the FTC or the Department of Transportation. So the thing to be aware of is to have a very good complaints handling process if you do the DPF, because there are many ways that you may find these complaints incoming. And again, with some of the activities we've seen from civil liberties organizations more recently, that I would expect a number of complaints. So is the DPF the right decision for you? Well, this was a very simple flowchart I did and posted on LinkedIn a little while ago. I actually think it's relatively accurate for what we see for a lot of clients. First question to ask yourself: have you maintained the Privacy Shield certification? Well, if you did, what was the point of maintaining it if you're not going to pursue the data privacy framework? So in that case, yes, you will automatically certify. You just need to make those changes to your notices and to your contracts. If you didn't maintain a Privacy Shield certification, or you didn't have one before, well, the obvious question you do ask yourself is the data privacy framework going to survive Schrems II? If you're feeling confident about that, then again, you may as well go ahead and certify. As I say, it eliminates the need to do those transfer impact assessments or argue around supplementary measures. But maybe you're not convinced. So the next question you ask yourself is, am I going to be put under customer pressure to have it anyway? And I would say probably more than anything else, that's been the main driving factor we've seen with a lot of clients. So if you're under that pressure, then yes, it makes sense to certify. If you're not, should we have it as a just in case backup solution, that layering of solutions to have that redundancy? Often that does make sense for a lot of organizations. But if you're not convinced by that, well, fair enough. Keep doing the standard contractual clauses. And as I've already mentioned, the executive order makes them simpler anyway, because they will deal with the points that you would mainly need to address in the transfer impact assessment in any event. So I mentioned this layering of solutions, and one of the questions we've also been asked quite a lot is, can I do the data privacy framework and the standard contractual clauses at the same time? Just to answer that question, you can certainly have both measures in place, but any individual transfer will require a specific transfer tool. And you can see that, for example, if you look at the EDP guidance for things like implementing supplementary measures, the first thing they say is identify the tool that you are relying on for the transfer. The idea is that one transfer requires one tool. So if you're transferring data to the US, you will need to decide, am I doing this transfer under the standard contractual clauses, or am I doing it under the data privacy framework? But if you are a vendor, then there is absolutely nothing to stop you offering both solutions as possibilities to your customers. And again, this is often what we see. A lot of vendors will say, well, we have the standard contractual clauses and we can sign those with this if you want, or if you prefer, we can transfer data under the data privacy framework because we are certified under that, and we can use whatever you want. I always think it's quite a nice approach. It's a very pro-customer approach to doing these things. And it means that you avoid those kind of difficult conversations where you have a customer who prefers one solution over the other, and it's not the solution you have. We have seen customers who want to see the DPF and don't want to use SCCs. We've seen customers who want to use SCCs and don't want to use the DPF. So the simple solution as a vendor is just to offer both. Or if you are in the fortunate position of having BCRs, then again, that's another option for you. If you are going to offer both solutions, though, I would just consider having failover drafting in your contract. What I mean by that is something in the contract that says if the tool you're relying on is deemed invalid, the data privacy framework is shut down, or heaven forbid, the standard contractual clauses are invalidated, it will automatically switch over to the other tool. So it's kind of automatically drafted into the contract that will happen. And the key benefit of that is that should one of those solutions be shot down, it avoids you having to go back and reissue contracts to people or to renegotiate contract terms. Much easier just to have the solution built in advance. So how can we help? If you are thinking of going through the process, we have a bunch of templates that we provide and sell to clients who are interested in it. We have a template DPF notice, we have template contractual clauses, we have an information gathering form for the types of information you need to collect in order to submit your application. And we have a short form data privacy framework self-assessment as well. So don't hesitate to reach out if you want to discuss any of those with us. So that brings me to the end of the presentation. I'm going to try and take a look at some of these questions now and see which ones I can answer. So one question coming in here: once certified under the DPF, do we have to have supplementary measures? The short answer to that is that no, you don't. The data privacy framework, as we mentioned, is an adequacy framework. So if you think of it as being similar to, let's say, Switzerland has an adequacy decision. You don't implement supplementary measures when you transfer data to Switzerland. It's just considered safe to transfer data there. The same thing with the data privacy framework, because it is an adequacy decision. If you are transferring data to an organization that has DPF certified, the fact that they have DPF certified and are compliant with the principles and benefit from the protections of the Executive Order 14086 is deemed sufficient in and of itself. There's nothing to stop you adding them if you want to, but it's not a requirement. So let's see, we've got a comment here. I don't see how an entity that is not registered with the DPF would get any benefit from it regarding your alternative approach. Well, so I assume the question that's being asked there is, how is it that you can rely on the executive order if you are not certified under the data privacy framework? The short answer to that is that the executive order was part of the groundwork to enable the data privacy framework to be adopted as an adequacy decision, but it is not part of the data privacy framework. It is an independent executive order. And what it is basically saying is that the presidency is laying down some rules about the conduct of intelligence activities in the US, and the fact that they must be necessary, they must be proportionate, there must be this oversight and this appeal mechanism. And they apply regardless of what mechanism you're using, whether it's the data privacy framework or whether it's the standard contractual clauses. And there are FAQs that are published about this from the Department of Commerce. There are also from some of the DPAs as well. I think from memory, it was like the Norwegian or the Danish DPAs published stuff on this. Even the EDPB, somewhat begrudgingly, has kind of acknowledged this in some of their FAQs they provided about the data privacy framework. So by all means, have a look at that. A similar question: are you proposing that standard contractual clauses get the benefit of DPF adequacy? Meaning that if contractual clauses and supplemental measures are not adequate in a given situation, then DPF adequacy can cover the gap. So, not sure I fully follow the question, but to try and explain what I was saying, the standard contractual clauses are one mechanism for transferring data. They're considered an appropriate safeguard under the GDPR. The DPF is a different mechanism. It's considered an adequacy decision under the GDPR. What I'm saying is that you can have both mechanisms in place. Particularly if you're a vendor, you can have the data privacy framework, and you can also offer your customers the choice of saying, do you want to transfer your data to us under the data privacy framework, or would you prefer to use the standard contractual clauses to transfer the data with us? And if that's what you want, we'll sign the SCCs with you. Any individual transfer must be under one or the other mechanism. You can't kind of say, hey, we're transferring under the data privacy framework and the standard contractual clauses at the same time for a specific transfer. But you can certainly have both of those kind of tools within your arsenal of options, and then use whichever mechanism you prefer for a specific type of transfer. Let's have a look. So there's a question here, very good question. Binding corporate rules are positioned as an alternative. Why are BCRs not subject to the same risk of excessive US government bulk collection and such? The short answer is they are. There's absolutely no difference. Binding corporate rules and standard contractual clauses are both the same type of transfer tool. Under the GDPR, they're treated as an appropriate safeguard. And if you were transferring data to the US under the binding corporate rules, any surveillance that takes place under standard contractual clauses can also happen under the BCRs. But what has changed is that, again, this executive order has put new controls on what the US agencies are entitled to do. So regardless now, whether you're transferring data under the SECs or under the BCRs or under the data privacy framework, these requirements around necessity, proportionality, independent oversight, and sort of binding decisions all now apply regardless of the mechanism. Another question here. Let's keep one eye on the time. Are US companies looking at, are EU companies looking at US companies in a negative light if they continue using SECs for the transfer of personal data from the EU to the US? No, I don't think they do. To be honest with you, it really depends. So the question is basically, if you are an EU company and you're transferring data to the US, is the experience that sort of European companies are transferring to US organizations, are they favoring the data privacy framework, and are they considering US organizations that are still using standard contractual clauses as being somehow a lesser standard? The answer is no. It really depends on the European company that's transferring the data. In most cases, EU companies are perfectly happy to use standard contractual clauses, in part because it's a homegrown solution. It's something that our European Commission came up with, adopted and found them to be sort of, an appropriate safeguard for transferring data. So we like them because they're homegrown. But, we do sometimes see organizations that just prefer to transfer data under the DPF. And part of the reason for that actually is that when you look at the GDPR technically in Chapter 5, which is the section that deals with data transfers, it actually has a hierarchy of sort of preferred transfer solutions. And what it basically says is that if you can transfer data under an adequacy solution, you should do so. If you can't, then you should use appropriate safeguards. And if you can't do that, then you consider derogations. So, we do find some of the perhaps slightly more technically minded, clients, customers prefer to transfer under the DPF for that reason. But it's, standard contractual clauses still have very good standing. In your view, is it worth certifying under the data privacy framework if we were not Privacy Shield certified? What are the main risks to be aware of, e.g., FTC enforcement? It's a difficult question to answer, and obviously everybody's context is slightly different. If it were me making the decision, though, I can't see a good reason not to certify under the DPF. Yes, there is a danger it may be shot down. Yes, there are some costs involved in going through the process. But I think, as I was discussing sort of earlier on in the slides, the data transfer environment has become so challenging in recent years, and the experiences over the past few years have been so difficult in terms of Safe Harbor getting shot down, Privacy Shield getting shot down, standard contractual clauses being revamped. We also know at some point there are going to be new standard contractual clauses, that are being considered by the European Commission as well, because some activities are out of the scope of the current ones. All of these things are just getting very, very complicated. And so, to my mind, having another sort of data transfer weapon in your arsenal as another solution that you can rely on, I think the more you have, both from a legal perspective, it gives you greater coverage. But I also think from an optical perspective, in terms of dealing with consumers, dealing with customers, dealing with regulators, showing that you've actually gone through the process of adopting lots of different ways of trying to ensure that EU data is protected is something that benefits you. The main risk to be aware of, I really do think it's around it is around that enforcement. A lot of organizations that, particularly US organizations that I deal with, are very worried about unfair and deceptive practices enforcement by the FTC. They're very concerned about increasing their regulatory exposure beyond the exposure they already have. But and because you have this certification requirement, and the fact that the FTC and the Department of Transportation can do ad hoc audits, it is not something to be taken lightly as a decision. It's not. I personally wouldn't certify and then consider it job done. I think you need to you need to do that assessment. Can I be in compliance with the principles? Then certify, and then maintain your ongoing compliance with those principles, because there is that danger that those kind of ad hoc audits might happen. And if you're found out of compliance, then the PR aspect of having your certification stripped from you and the enforcement aspects, I think, would be quite risky. But on balance, yes, I overall do think it is a positive thing to do. A question here: we use failover drafting, which sets up the privacy framework as the primary tool of choice while valid. Can contracts refer to the data privacy framework or successor legislation, and will they work until we? Oh, sorry, I see. Can contracts which refer to the privacy shield rather than the data privacy framework or successor legislation work until we get to updating them to specifically reference to DPF? So in other words, we mentioned earlier that a lot of the requirements under the DPF are very similar to the Privacy Shield, almost identical, in fact. And under the Privacy Shield, lots of companies already included language in their contracts that said you're transferring data to us under the Privacy Shield for as long as it remains valid. And sometimes people said, well, you transfer data to us under the Privacy Shield for as long as it remains valid, or any successor to the Privacy Shield. The question is, now that the Privacy Shield isn't valid, is that existing language which refers to the Privacy Shield in contracts good enough to enable you to receive data under the data privacy framework? I think probably the best answer I can give you around that is it's a risk-based view if you decide to do that. I mean, the only way I think you can ever be 100% comfortable is if it's really clear that you're relying on the data privacy framework for transfers. Having said that, if your language is along the lines where you say the Privacy Shield or kind of any successor to it, then you probably got a degree of comfort there that it covers your subsequent data privacy framework certification. But again, it will depend, I think, on the specific language, and it will depend not just from a regulatory aspect about how the FTC or the DOT may feel about it, but also how customers feel about it and whether they consider it, a potential breach of contract if you're continuing to use that as your tool. However, if it is the kind of thing where you've said we're using this, but we can fail over to the standard contractual clauses, then again you have got that redundancy. So even if somebody disagrees with you, you arguably have got that coverage through failing over to the SCCs. I think with that, I am just about getting to the point where I've exhausted myself on questions. So I'm going to thank you very much to all of you for attending and supporting this webinar. It's great to see so many people joining. Digiphile will be doing future webinars over time. I hope to see many more of you there. If you enjoyed this, thank you for all the thumbs up and everything on the screen. It's lovely to see. Do tell people about us. Do send us nice messages. We're terribly vain. We love to receive them. So thank you all for joining, and we will hopefully see you again soon. Cheerio.